Hey, welcome back to the House Judiciary Committee. Be our last witness on H606. Matt, thank you for being here.
Yeah, no problem. My office has weighed in on these issues over the year, and I'm Matt Valerio, Defender General. We've weighed in on these issues over the years, and I always, and I've discussed these with Rebecca Turner, who used to come in and do these, and she's the true expert on firearms rights and the like in our office. But we always start, like we're discussing, like as a matter of policy, we aren't taking any particular position except for that we, as the Defender General's office and every lawyer, should be saying that we are going to stand to defend the constitutional right to bear arms that is included both in the federal and Vermont constitutions. And whatever you do that mitigates that, lessens it, or the like, eventually, necessarily, is going to end up in our laps in some case at some time. And then we are going to figure out whether what you did was constitutional. The interesting thing about this area of litigation, and my office has taken cases and under my name to the U.S. Supreme Court on these issues, is that it's very difficult to predict what is, as people try to whittle around, I do think you do that, try to limit gun rights under the Second Amendment and under the Vermont Constitution. What is legit and what isn't? It's very difficult to predict. Many of the decisions that have come out tend to be at the state level very results oriented, as opposed to if we look at case law, it's very difficult for us to predict based on case law how the Supreme Court is going to rule. But you look at a particular case, you might have a particularly unattractive client, and you might be better able to predict the result in the individual case than you can the constitutional determinations of the right that is being argued at the court. So this area that you're delving into in H606, and I don't know what version you're up to now, right now, but in general is looking at how are we going to limit the right? You start off with a kind of full-blown right to bear arms. And then under certain circumstances, you can limit that right legally and legitimately, constitutionally. The question is, can you do that in this particular case, like what you're trying to do in 606, or not? Or have you been overly broad in carving out the area that you are attempting to carve out to limit access to firearms to the people who are involved in these in the areas that you're talking about? And part of what you're talking about is the people who have been subject to mental health orders, right, at various times. And I can look at the case law that's out there, and clearly there's an ability to limit, on occasion, people's rights to, if they are, if they've been adjudicated dangerous, based on mental health issues, based on criminal activity, under federal law that's been incorporated in state law. The question is, you go too far, or did you not go too far? And that's like on its face. Then the second issue is, as applied, did the government acting go too far? Or did it, or is it okay? And so you start running through, and I haven't had an opportunity. This was a tough subject to come up 2 days before crossover, to be perfectly honest. A lot of, I'm sure I can see there's a lot of people interested. And so I don't want to necessarily, I don't know what everybody has said. I've heard little pieces here and there. I haven't been able to, I have not had the time, honestly, to hear what they've all said or read testimony or that kind of thing. But I can conceive of groups of people who would be captured in the proposal. It's primarily on, I have draft 1.1, which is probably 5.5 at this point, but who knows? I have 1.1. There we go. Not too bad. I'm only 1 or 2 versions behind. But on 6 of 8 of 1.1, people who have been found by the court to be a person in need of treatment and or not guilty for reason of insanity, competent to stand trial, subject to a commitment order, subject to a hospitalization order, and subsumed within those groups are people who you don't want to have guns, and you can probably legitimately deny the right to. But also subsumed within those groups are a whole bunch of other people who would be perfectly fine having a firearm for purposes of hunting or self-defense or any other reason. And so I know what you're getting at, but the breadth of what you're doing seems to me on its face to be too broad. As applied, however, and this is where things always get interesting, what's the case? Like, what's the client? What actually happened? You know, it's going to arise depending upon what individual, like this may be too broad, but as a case develops over a period of time, what kind of case is it? You know, is it a multiple shooting case where somebody has been found incompetent or insane? Or is it somebody whose father has died and had a psychotic break as a result and was hospitalized for a month and was treated and came out and is perfectly fine? And actually where they find their zen is by hunting. And I have a tenant. There was a guy who was in the military for decades and had some trauma as a result of being in the military and doing what people in the military do. And he had this exact, kind of issue. When he got out, he had a breakdown, ended up being hospitalized. And he also had an alcohol problem. And got in a bar fight, got charged with aggravated assault, ended up being convicted at some point, but then was kind of relieved of that. He couldn't own a firearm because convicted felon. But he wasn't a gun violence guy. It was I'm a drunken idiot guy. And but he wasn't able to own a firearm yet. Every year, when the time was right, he would hunt with a bow, or he'd hunt with a black powder rifle, or he would hunt with a crossbow, or any of the things that you can hunt with. And because when he was in the woods and he was doing that kind of thing, was the place that made him calm, made him feel good. The time when he was hospitalized, as he was working out some of this stuff, was after he was relieved of that. You could petition and relieved, this was actually in New York when this happened, but relieved of that, the trying to state it in a way that's more colloquial. I'm not doing a good job of it. Bottom line is you can get your right to get a gun back. And he did. And then he was hospitalized later for like the problem that he had mentally. And then that was treated and he's out. And he still hunts with all of the things we talked about, which is, satisfying. We'd like to go deer hunting with a regular rifle. And under this, he probably wouldn't be able to. At least under as it was written in 1.1. I don't know what the latest version says. But so to me, that subsumes more of a population than maybe you're even intending to get at. You definitely sort of throw the baby out with the bathwater by including everybody. You definitely get everybody. But that's when you're looking at addressing constitutional rights, you have to tailor what you're doing to a very specific kind of group so that you don't incorporate people who should not appropriately be denied and who have not been shown as a danger or a threat. And there are all kinds of reasons under all these criteria why you might end up, one of the really interesting things is like a sanity defense. It doesn't mean your sanity is unique from competence, because you can be insane at the time of the offense for whatever reason. I can go into some of that if you want it, but it's not worth it. And then not be insane after, but you're not legally responsible for what occurred in the incident that gave rise to the crime, and then you never have a problem again. Couple of ways you get around the issue. And did you put back in the ability to petition the court to, in the first version, had the ability to petition the court to get
That was introduced.
Right.
That's not in there. The idea is that it is when the order of hospitalization or order of non-hospitalization is not in place, then they do not have.
then you don't have the disability anymore.
The rights are restored.
Right. So to me, I think at a very minimum, there should be a specific restoration right. You can have like default rights where when the orders are no longer in place, you might want to, for some stuff, you might want to say, well, then you no longer are under this legal disability regarding your Second Amendment rights. But at the very minimum, you need to have the ability to petition to have those rights restored. The first version I saw had that. The second version didn't have it. I didn't know, I would want to see that kind of be specific just to make sure that you're getting in the range of being constitutional. So there's an option to affirmatively restore your Second Amendment rights if you fall under one of these categories. The other thing is, though, and it gets
Jack,
Well, this is, I think, I really appreciate the point that you're making, Matt, and I think this is more a question for the chair, is if that petition can be added back into the legislation.
it can be. Anything can be done. I'm looking to see if it would upset
I guess-
the apple cart of what.
Should I say, will we do that?
Don't know yet,
Okay.
but we'll consider it.
Can
I'm
I'm
looking at it right now.
ask for a point of clarification?
Point of
I'm not-
clarification on the same thing. Yeah.
So are you saying, Matt, that right now, as it is in 2.1, it says it is the subject of a commitment order?
I can't tell you anything about 2.1.
I know, why I'm reading
Go
it.
ahead.
Is the subject of a commitment order issued by the court, or is the subject of a hospitalization order issued by the court?
Page 6.
Hospitalization order. Page 6, lines 14 through 18.
Yeah, got it.
And my understanding is that language was very carefully crafted. That the word choice is very specific to be clear that the rights of possession are restored once that person is no longer the subject of the commitment order. Once that has expired, or however it's disposed of, there's an automatic restoration.
Why don't you say that?
I don't know if I can write the language, but I'm wondering if that's the same language that you're.
It's not apparent, but I could see how you might infer that. But it's not apparent, and if that's what you intend, you should say that. I also think there should be the ability to.
Why would you need to petition?
Well, what if you are under order of non-hospitalization, or you've been found incompetent to stand trial, but it has nothing to do with an issue of violence, you know? You might want to.
The petition for an exception, not really a restoration.
Well, it's a restoration based on the fact that notwithstanding your mental illness, you are not a danger.
Isn't that baked into the finding?
It's not apparent.
I don't think it would provide any problem putting what was paragraph C back in. I mean, we have a whole procedure, it refers to the whole procedure we already have in here for when, for petitioning to have their firearms back, due to mental illness. So, I mean, it's there.
To me, because what you're doing, you're wading in constitutional waters, right? So what you don't want to do is be vague, and even though you might reasonably infer what you're suggesting to be the case, you don't want to leave it to interpretation. You want to tarot it. If you want it to stand up to constitutional muster, you want to tailor it as narrowly as possible to get at specifically at the group. And if those rights are not intended to be taken, you have to tailor it as narrowly as possible and be specific about what you're trying to do. Now, I don't doubt, and I don't disagree that these, as written, you can infer exactly what you're suggesting. But I think when you're dealing with constitutional rights, the more specific and explicit you are to make sure you withstand scrutiny, the better off you're going to be.
And I guess on the constitutionality question, in your view, Matt, as it's currently written, that this would probably find the face of a constitutional challenge.
I would say so.
Yeah.
I just think it's overly broad. And while it might infer the right group of people, it also subsumes a larger group that, first of all, I don't think you're really intending to get at. Maybe you are. But if you are, I think that's going to be a problem for you.
Can we get Julio in?
Probably not.
So there's not going to be any more testimony at this point after Matt.
Correct. I mean, there can be more testimony, of course, in the Senate if the bill makes it over there.
There was one other weird thing, and I don't know if anybody else brought this up. Like I'm speaking kind of generally about like how you address this. There were two other things I kind of wanted to talk about. I know there's always an inclination when you see somebody who has violated something like this to create a crime as the response. But it's somewhat like logically inconsistent and a little bit nonsensical to identify somebody as being incompetent to stand trial and then not able to possess a gun and then create a crime as the remedy for someone who you already have adjudicated as incompetent to stand trial. You know what I mean? Because it's one of the conundrums of our mental health system as a whole, right? So this is what happens. It could be anything, right? Someone could be, say it's unlawful mischief. That's a good one because those happen. And the person is like not competent. And the person's found not competent. They're released on an order of non-hospitalization, for example, because they're not particularly dangerous. And the next day, they commit unlawful mischief. Then what happens next? They get arrested, they get brought back to court, and they get charged again, even though literally days before, and this, I swear to God, this happens over and over. They were just adjudicated incompetent. they're under an order of, a non-hospitalization order. And now we're back in court with a new criminal charge, even though they're literally under an order saying they're not competent to stand trial. So I just find it a interesting response to create crimes for people who have been adjudicated incompetent, insane, or otherwise subject to mental health orders, where you say you're not competent, but we're going to charge you with a crime. Like, the incompetence removes you from the jurisdiction of the criminal court. Now, there might be other things that could be done, and I don't want to legislate for you.
Yes, you do.
No, I don't. I really don't. If I could, believe it or not, as to this issue, if I could go back to corrections and institutions right now and talk about gender identity issues, I'd be happy to do so. But if there were a confiscation issue or a forfeiture kind of, if somebody's already adjudicated incompetent, if there was a procedure to, confiscate the weapons, as opposed to, like, why create a crime? What to somebody who's already been adjudicated incompetent? It doesn't make any sense. I know it, I get it. But the criminal justice system doesn't solve this problem. It's another part of government that solves this problem. Because if they're incompetent, they're still incompetent, especially if they're under an order, or, and then if they are competent, and it wasn't a violent crime, you've subsumed somebody into the proceeding that shouldn't be there to begin with, yet they're subject to a crime. So this is how this is. I just want to play out for you how this is going to come back if you pass a bill that is too broad, and then how, as defense lawyers, we're going to attack what you did.
So I have Zach, Angela, and Ken.
So 2 questions, Matt.
I wasn't paying.
Insofar as the mental health section of this, would you find the bill as currently written prejudicial towards people with mental health?
Well, yeah, and prejudicial to people who want it. Yes, but it is, yes.
And so you're right.
But it's what it is. It's really not a prejudice issue to me. It's overly broad from a constitutional analysis standpoint. It may be, because, like I said, I don't know how any particular court's going to rule based upon precedent, because these tend to be very results oriented based on individual cases, as opposed to, but it looks like it's subsuming a population that is greater than it needs to address the issue you're trying to get at, which is a legitimate issue, but it's overly broad. So it's an overbreadth issue constitutional.
I appreciate that. So, and I just want to check my own understanding that if we were to remove Section 3 from the bill, that would remove some of the constitutionality concerns that you have, and kind of the prejudice towards people with mental health.
Well, yeah, I mean,
If you struck Section 3.
Yeah, if you
that's the constitutional concern that you have.
Yeah, if you struck Section 3, absolutely.
But can we strike Section 3?
Excuse me, we could do anything. No comments from the gallery. So we can discuss all what we want to do with this later. We're going to have open discussion.
After Matt leaves.
Probably depends. We have a couple other things to do before we vote it. So tomorrow, it might be tomorrow we'll have the discussion if we don't get to it today.
So those were I get more questions. Happy to answer.
Go ahead, John. My question will probably be answered from me.
No, it won't. Because I don't know.
No, we call that.
I'm good, but I can't read your mind.
That's good.
Matt, do you think that the federal law 18 U.S.C. subsection 922D is constitutional?
Well, it's been found to be constitutional.
Right, and so
On its
we're
face.
using pretty much the thing, where our law is actually more narrow, less broad than the federal law, so I'm confused.
Well, our Constitution Vermont Constitution is also different. And see, this is the thing, it's as applied. if you look at that on its face, can it subsume people who are not who you're trying to get at? Yes. But as we go through it and we look case after case after case, maybe we just haven't had the case yet that elucidates the idea of the overbreath, you know?
We haven't, but there have been a number of cases at the federal level, which really shed a lot of light on what we're doing here.
Yeah, and
It's
honest,
shown over and over that it is in fact constitutional.
then you should try this and see what happens.
Okay,
But I'm just telling you, I'm giving you a warning about how people would approach it. I'm not taking a position on what you should do or not do. I'm telling you how a lawyer is going to pick this apart. And so, you know, I'm not here as an advocate. I'm here as an analyst. And, you know, I don't know if the AG's office showed up on this. John Treadwell used to be here before he became a judge. I love the fact that he was here because we'd sit here, analyze things, agree 98% of the time. And then the committee go, oh, Attorney General and Attorney General's office all agree. And everything be fine. But there's absent on some of these issues now, and I wish they were here. So in any event, that's just an aside. But
I know you're waiting to hear from me. So, but you already said it. So you've already set the word out there that this bill is set up for you as your job as Defender General. You're just going to pick this apart.
well, I would do with it whatever you did.
Oh, I am. But that's your job. That's totally your job. And I respect.
I'm telling you how whether it's me or somebody else, how a lawyer would analyze a case that came to them in the course of, you know, what we do and how we would look at attacking the legitimacy of the statute, the legitimacy of the conviction, or how it's applied to the particular crime. You know, it wouldn't, there are times where, you know, we take cases that, and I'm not talking about firearms cases at all, but an individual client's case that we can win ends up hurting every client that we're going to have for the next 10 years. But we have to represent that client that's in front of us that day. It's not normal thinking. You know, it's not what the general public or lay people, how they conceive of the world. But it's what we do every day. It's law school changes your mind and the practice of law. You think about everything differently. You know, someone gets in a car accident before you go to law school and you wonder, you know, is everybody okay? You know, and when a lawyer looks at it, they wonder, oh, is there liability? Is there insurance? Is there, you know,
that's
who's
my loss.
yeah, you know, it's a different kind of person who does this stuff. But the bottom line is I'm just trying to tell you how we would look at it.
I know, I appreciate it.
So the only thing, and I don't know if it's in latest versions or not, there was an oddity that I noticed, and I made a little note because I thought it was odd. It was a definition of firearm. And there,
At the beginning, there's,
yeah, and I made a specific note on it only because we have multiple definitions of firearms.
Yeah.
And, oh yeah, in 13 VSA 40, I don't know if anybody ever talked about this because it's kind of so deep in the weeds, but it's the 4016 versus 4017 definition. And the 4016 one is like much broader.
Yeah.
And you chose that one, which is not like the,
Changed to 47.
oh, okay.
Because of Chris Bradley's fine testimony on that particular issue.
Oh, you? Oh, okay. Well, yeah, I mean, I was like, I was reading it, I'm just like, why'd they choose that one? But anyway, I don't know why. Maybe there was no particular
You
reason.
have to ask Ken, because he was a co-sponsor of the bill, so you can ask him why they chose for it.
Friends behind it?
On this part that went into your first section. Just kidding, he wasn't the lead sponsor.
I was gonna say that's a little.
I know,
That's a little unfair.
I was unfair. That
That's
was
a little
purposely.
I didn't do the unfair,
Oh, no.
just so that the record reflects.
It's, and, position.
Is this your copy? You can have it.
Thanks.
That was the only thing that I wanted to point out, and that the definition was the last piece.
Yeah.
And I take, again, to be clear, I'm not an advocate. I'm not taking a position on this bill. I'm just telling you how we would attack this in the event that a case arose under this statute for us, and kind of pointing out from on the criminal side of it, that there's like the logic to charging someone with a crime who's already been adjudicated incompetent, or is subject to an order that that would subject them to the criminal liability. So you got to think about that. But otherwise, that's all I have to say.
Well, I'm sure Alice would be excited about getting you back. After
No, I
Pat
just
asks some
want
questions.
to, I just want to thank you for your explanations and your examples. Sometimes in the past, we get, I'll just say, people in your capacity that come in here and might have a similar argument, doesn't do as good a job explaining the position. So I just want to thank you for
Yeah,
that.
no, I appreciate it
No
too.
problem.
Appreciate
Thanks,
it.
and
Thanks for making it. And thanks for your flexibility.
thanks for accommodating.
So
I have a question on this while we're here. So
Sure.
can the committee expect any further changes on the legislation as drafted?
No, I'm going to suggest
Thanks,
getting
Matt.
subsection,
C.
the petition.
The petition.
I'm going to suggest 445A.
And so we're not going to hear from any constitutional law scholars.
So, no, that the intention, I mean, so we're looking, that doesn't mean that we're not worrying what his arguments were. As Angela pointed out, this kind of thing has been upheld a lot, and we've had some of the other witnesses are in fact constitutional scholars and have done a lot of work. Well, Billy Clark has done a lot of work and has testified on the constitutionality of these past. People from every town has as well. We haven't had somebody from the Attorney General's office generally testifying on that or issue spotting for us. That way in the past, just in recent years, there hasn't been like the person there.
So they wouldn't come in on a gun bill? The Attorney General's office?
They haven't recently, not in recent past, I know. But the point is that mental health has been upheld, and actually, I'll explain a little bit further. But in 13 VSA 4822 and 4823, 4822 is with respect to. Let me just make sure. This is where there's a finding. This is what we're basing this on. It's 4822. And we already have laws, and I'm going to tell you what it is, 4824, where an individual who is subject to treatment pursuant to 4822, we submit to the NICS system. And that we've not, we looked at that issue as far as whether that may be appropriate or not. And at that time, it's been upheld. Actually, I don't think it's been challenged. That's where the petition issue is. 4825 is right after that. It's a petition. I'll add that back.
Right.
But the thing is that with this, so for the NICS system, we're sending up any order where there's somebody in need of treatment under 4822.
Right.
And the way they can get out of it is a petition. This actually is narrower than it doesn't narrow it to crimes of violence, under section 4017 or so this actually narrows what we're including in ours and what we're sending up to NICS.
And we're not going to hear from ATF.
No, we've tried to have ATF in before, and we've never been able to get ATF.
So my thing with this, and I know that we're going to have additional discussion tomorrow, is that given that we have heard concerns that there is a constitutionality, consideration here that I don't know if it's being fully entertained, because I really have real reservations about passing anything out of this committee written like this, especially with sections 3 still in there. And I fully intend on talking to Senate Judiciary to express those concerns from myself and others on the committee. But at this point, given that we're not going to hear any other testimony on this bill, I would move that we report H606 adversely from the committee.
Yeah, I mean, we can consider that tomorrow and I can reach out. If we're fine, if we're all fine to tomorrow afternoon.
I think you just called for a vote.
Yeah, well, I'm suggesting an alternative. We're all fine.
I'm not backing down from the vote, Martin. I've
The
made a motion.
Mason's rules are when a vote is called for, you have to vote on it.
Or I can recess, which I'll just recess for now and I'll review.